like you, be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host Pavarotti, and I'm here to discuss the Idaho 4 case. Now, there has been some new court documents that have dropped, and one of them is very interesting because it lists basically outlines of all of the exhibits defense brought up in the Frank's motions. And there was also something else from the hearing that, I almost slapped myself in the face yesterday as I was listening to it again, and it was the first couple of words of the hearing, and I just didn't catch it. And I haven't heard anybody else even mention this either. I think we all missed it. So I'm going to touch on that in this one, and then I'll have a video out later today that goes into more detail about it because it's huge. It's huge. And I don't know how I missed it. But in this first video, we're going to dive into those recent court docs. There's a few of them. And, I'm almost giddy as I wait for those transcripts of the secret portion of the hearing to be released. As each day draws closer to those things actually being released, I'm going to get just a little bit more nervous. Now, can you imagine how many pages of transcripts those are? And it'll take some time to pour through those, but I believe there is a wealth of information that's going to be released in those transcripts, redacted or not, because we can glean, people love when I say glean, we can glean so much information just from reading highlights of the ones that I'm about to show you. So without further ado, let's just get right into it. First, we have this order from the judge extending the deadlines to file motions in limine and reset hearings. Now, the defense and the prosecution both filed extensions for their deadlines for the motions in limine, and they stipulated to each other for the extension. And in their motion, they put up suggested dates. And you can see that the judge has ordered it based on their recommendations, which is interesting. This judge doesn't seem like he'll be too apt to change his original scheduling order. However, since both of the parties agreed to the extensions and they don't appear to affect the trial date, then he ordered that that it was okay. And you can see the court having before it the stipulated motion to extend deadline to file motions in limine. We'll talk about motions in limine here in just a second. And good cause appearing now, therefore it's hereby ordered that all motions in limine shall be filed no later than February 24th, 2025. All responses shall be filed no later than March 17th, and any replies should be filed no later than March 17th. So they want to file their motions in limine. They got to do it by the 24th, both parties, that's defense and prosecution. And then their responses better be in before the 17th because their replies are due the 17th. So I don't know if that's exactly, I'm going to have to look at their original stipulated motion and see if that's what they suggested. I would think that they wouldn't suggest the replies and the responses be due the same date, but maybe they did. But it is further ordered that the hearing date to all the motions in limine shall be rescheduled for April 9th, and if necessary, continue to April 10th. It is so ordered this 30th day of January 2025 by Judge Hippler. So we're going to have to do a couple of things. Number one, I need to really check their, I don't guess it's that important right now, but I need to check their original motion and see if they actually suggested these dates be the same. But also, we're going to have to adjust our spreadsheet, because now we've got our hearing dates have changed and the deadline dates have changed for these things. And, we like to keep everything nice and tidy on things that are happening in this case. So we will adjust that and take a look at that here in just a minute. So that way, if you want it, you have it just like I do. But let's talk about the motions in limine and what that really means. Okay, a motion in limine is a pretrial motion that seeks the exclusion of specific evidence or arguments from being presented during a jury trial. So very important, it seeks the exclusion of specific evidence or arguments. So when they say exclusion, that means they can't bring it up. So this goes towards the prosecution and the defense. So if the defense right now, they're trying to get motions suppressed and evidence suppressed, but in the motions in limine, they'll try to get it excluded, which is a similar way, either way, you don't bring it in at trial. But the main thing that they want to get excluded is the arguments from being presented during a trial. Now, this is huge. So a motion in limine is decided by the judge outside the presence of the jury. The purpose of a motion in limine is to address potentially prejudicial, irrelevant, or inadmissible information that could unduly influence a jury or hinder the fair administration of justice. So by filing a motion in limine, attorneys aim to prevent the opposing side from presenting evidence that could be highly emotional or legally problematic, thus avoiding any potential prejudice that could arise. Motions in limine are particularly valuable in cases where the mention of certain facts or information could taint the proceedings, and where the potential harm caused by their introduction might be irreparable. Motions in limine are often used to limit or exclude expert testimony under the Daubert standard. Such motions regarding expert witnesses are usually filed after the close of discovery, which, according to the record now, we are past the close of discovery, even though there's many motions to compel that the judge did not, actually order on. So I don't know how we're past the close of discovery, to be honest with you, but with a hearing on the motion in limine held prior to trial. So a couple of things I want to point out. Particularly valuable in cases where the mention of certain facts or information could taint the proceedings. So if you look at it from the prosecution's point of view, they would probably like to bring in Mr. Kohberger's prior drug use and potentially current drug use at the time of arrest, and the defense would want that excluded because it would taint the fair administration of justice and it would be prejudicial to the defense. On the other hand, the defense is absolutely going to want to present opposing what am I trying to say? They're going to absolutely want to present alternate suspects, all right, an alternate suspect theory. They're going to want to present evidence that I can assure you is related to the drugs surrounding this case. And they would also like to bring in, I'm sure, the other incidents that have happened there in town. The more that we learn about DM's actual statement, well, the more that first case that happened in Pullman that they were trying to pin on Kohberger, who didn't even live there. But now it becomes even more relevant because she said the guy was short. Now we get DM's real statement, and she's claiming the guy's 5'8" and skinny. Well, that almost mirrors that little weirdo that was breaking into the girls' apartments in Pullman now. So I'm sure the defense would like to bring all that in, and the prosecution's going to want to try to get it where they can't bring it in. And that's why the motions in limine are going to be now that we're past the motions to suppress, depending on what the judge rules, the motions in limine are the next critical point in this case. And we've got the new dates for everything, so I'll put them in the spreadsheet and show them to you before we're done with this video. But here's something that I think is very important. And I did a video on this a while back, and I was talking about the Daubert and Frye standard, because that's the standard that most states actually follow. It's called Daubert-Frye, and it's related to the testimony of expert witnesses. Now, I've mentioned that in Idaho, they actually don't use the Daubert-Frye standard, and I did have somebody, in my comments that, they disagreed with me and said that Idaho does. So I did, based on that statement, do more research, and I think I am correct based on what I'd found. Oh, but this is another point that I wanted to make, and this is why this is going to be so crucial. But this is an excerpt from the Delphi case. Prosecutor Nick McClellan filed a motion in limine asking the court to bar the defense from mentioning the alternative murder theory or other potential third-party perpetrators during the proceedings. The judge ruled in his favor. So during the Delphi trial, they couldn't bring up the FBI's report on the Odinist angle, but they also couldn't bring up the fact that freaking Ron Logan confessed to a guy in jail and gave information that was very pertinent to the case in his confession, and he happens to pretty much be the bridge guy. So, and you got to give some massive kudos to True Crime Design and Drip Drop, because they've been saying that Ron Logan was the bridge guy for years now. And when you look at Ron Logan and the clothes he's wearing in the video of the bridge guy, you can clearly see Ron Logan was bridge guy. No wonder none of the witnesses in the trial could identify Richard Allen as bridge guy, which is beyond me how they can testify. Witnesses can testify to a bridge guy with the defendant sitting there in front of them, but they can't testify that the defendant is bridge guy. I mean, that was just insane to me. But that's an example of what could happen in the motions in limine. Now, as far as Daubert-Frye, Idaho does not use the Daubert or Frye standards for expert witness testimony. Instead, Idaho uses Rule 702 of its Rules of Evidence. And again, this relates strictly to expert testimony. However, Idaho courts have used some of the Daubert standards to assess the scientific validity of expert opinions. The Daubert standard, case law used to assess the reliability and relevance of expert witnesses' testimony before it is presented to a jury under FRE 702. It has been adopted by many states in addition to being used at the federal level, but Idaho has declined to explicitly adopt Daubert, though it still applies some of the factors. January 16, 2024. So as of January 16, 2024, then no, they still do not hold Daubert or Frye as the law of the land. Instead, they use Idaho Rules of Evidence 702, testimony by expert witnesses. And this is important because, the defense and the prosecution have both just presented their expert lists with their expert testimony. And we heard the judge in the hearing the other day really hammer the prosecution to be overly disclosing their expert testimony. But you can see that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. And that's been their rule their rule since March 26th of 2018. Now, so what that means is when you start to look at the expert witnesses that are going to testify to, for example, cast data on location, which we know they've already hammered them on that. But mainly, I think the expert witnesses are going to come into play when it gets to the DNA in the case. But I just wanted everybody to be clear on what the motions in limine were and what the rules around them are as well. Now we're going to take a look at that spreadsheet to make sure we're up to date on everything. Then we'll go to the next court doc. Okay, so here is our schedule. And you can see everything I've got here in yellow. This is all already taken place. We're waiting on rulings. But now we're changing the date for the deadline for the motions in limine to be filed to February 24th. And then the responses are due March 17th and the replies are due March 17th. Now, here's an interesting note. Let me show you. I went ahead and looked it up. Okay, so this is the original motion that was stipulated to, and this was actually filed by the state, but it was, actually it was filed by the defense team, but it was stipulated to by the state. And you can see, just like I was kind of shocked when I seen those dates, they actually suggested motions in limine deadline be February 24th, response deadline March 17th, and then reply deadline March 24th. So they actually were trying to give themselves a week for the reply in between the response, and the judge agreed apparently to the first two deadlines being moved, but then the reply deadline, he kept it at March 17th. So now I guess they better hope that they get their responses in before the 17th so that they can get their replies in before the 17th. That's a pretty tight deadline, the same day responses and replies are due. So, and you can see I've adjusted that here on this to responses to limine 17 or replies to limine 17. So after that, I mean, we're getting really close to the trial. And you can see I've adjusted the motions in limine hearing that was scheduled for April 3rd. Now it's scheduled for April the 9th. And then after that, I mean, you've got just the trial briefs. There's a closed hearing for the jury questionnaires, proposed jury instructions, brief objections. Okay, so we got the trial briefs, the brief objections, copies of the exhibits have to be in April 21st. The guilt phase lay witnesses, which means any witness that's not an expert, the 21st. Rebuttal penalty experts, the 28th. Now that's if Kohberger was found guilty. Whenever it goes from guilt, that's the trial to determine guilt. Penalty always refers to if he's found guilty, the second part of the proceedings when it relates to sentencing. Penalty phase lay witnesses. I don't have a date for that one for some reason. Spreadsheet of exhibits due May 14th, and then they're going to have a pretrial conference on the 15th, voir dire on the 30th, trial starts August 11th. And the next thing I want to mention before I get into the next doc, the next doc is really interesting, but over here I had the list of all of the motions to suppress that we're waiting on rulings for, and this is what I caught watching that hearing again. In the very first statement of the hearing that we watched the other day was, I didn't even put two and two together because the motion for the Franks was really separate from the motion to suppress the genetic information, but it was also part of the Franks motion, the motion to suppress the genetic information. So they were like two peas in a pod. And we haven't heard for sure if the judge is going to grant a full Franks hearing for all the information that the defense has brought up. But one thing that he mentioned in the start of that hearing was the motion to suppress the genetic information was an actual Franks hearing. So what we're waiting for the transcript on, that wasn't just a hearing. It was literally a Franks hearing, and that is freaking huge. Let me show you what I'm talking about.
Are we ready to go live? All right, go ahead. Let me know when we're ready, Sandra. Ready? All right. We are back on the record in State v. Kohberger, CR 0124316665. We are now, I believe, streaming for the record. The defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Franks motions filed by the defense. That will include the Franks hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Franks issues as to why the court should hold a hearing on those matters. That will include the Franks hearing that was held on the IGG issue. That will include the Franks hearing that was held on the IGG issue.
I didn't catch that. You know, the whole purpose of the hearing that we watched the other day was for, obviously they were arguing the motions to suppress, but a main portion of the argument was so that the defense could actually receive a Franks hearing. And there's 5 standards that have to be met to even receive a Franks hearing. And a Franks hearing, again, is on lying or omissions of important facts by law enforcement. So that means the closed portion of the hearing on the IGG was actually a Franks hearing. That means that judge scheduled that hearing based on pertinent facts that deserved a Franks hearing. So it's huge, because depending on how the judge rules on that genetic information was tied to almost all of the other motions to suppress in their main arguments, along with other arguments of the Franks itself. So I didn't realize they actually had a Franks hearing on the IGG. It wasn't just a hearing to discuss whether they should have a Franks hearing. It was the Franks hearing. Folks, that's huge. That tells me that's why Massoff sat there and you couldn't, get the smile off of her face the whole hearing if you tried to pry it off with a can opener. It was like she was on helium. I'm trying to figure out why. I knew something happened in the closed hearing, but I didn't realize that closed hearing was a Franks hearing. So, we don't know where we're at in this case right now. It may be getting close to getting up and getting out of there. But later on, I may get it out this evening. I'm going to do a video based on all the information I could gather from the motions to suppress the genetic information, so that we can see what we can glean from the Franks. Until we get the transcripts, we're just speculating, but I like to speculate. But we're going to go ahead and move forward now to the next doc, which I think is very interesting. They, in an order, they showed all of the highlights, basically, that the defense was putting forth as it relates to the Franks motion and the exhibits, and it gives us just the headers, but the headers tell us a lot, I believe. So let's go through it. Okay, so we've got this notice of filing list of stipulated exhibits for motions to suppress and motions for Franks hearing. And what they've got here is attached to this is some incredible information. This is the exhibit numbers and just a description of what the exhibits are for each one of their arguments in the Franks. And you can see the first one here is email communications between, now remember, anything in this, the defense is pointing out that this is it's for the Franks. So it's either lies that they've uncovered or intentional omissions that they've uncovered. So the first exhibit, we got email communications between Detective Payne, FBI Agent Balance, and Latah Prosecuting Attorney's Office, the Latah County Prosecutor's Office. So that means that the prosecutors were well aware of whatever the heck the defense is talking about right here as far as lies or omissions. So they've included the Latah County Prosecutor's Office. Then we've got an email with additional probable cause attachment from FBI agent Nicholas Balance to Brett Payne. Wonder what that said. And let's see, email working with draft for search warrant for AT&T from Brett Payne to FBI agent Nicholas Balance. Exhibit A, statement of Dustin Blaker, affidavit presented to the judge in Washington. Affidavit for search warrant for Google. Affidavit in support of arrest. So that's the PCA. PCA. We know she tore that apart. Transcript from the 5/23/24 motion to compel. Transcript for I believe these were hearings, so I believe 5/24 was a motion to compel hearing, and I need to go back and revisit that hearing based on that and see what I can gather that the defense is saying. And then we got the cast report, the draft, and the full cast report, meaning they actually received it finally. And then we've got the affidavit of Cy Ray. So all those guilters out there that suggested that Cy Ray was no longer on the case, I can tell you he's listed in this several times. He is definitely still on the case, and the guilters are full of lies and ridiculousness. Check this out, though. Affidavit of Tom Slavinsky. Guess who Tom Slavinsky is? I've done some research into him, and I think you'll find this very interesting. Okay, here's Tom Slavinsky's site. Thomas Slavinsky. Experience the Cosmos. And he does a lot of stuff on astronomy, introducing Starlight Adventures. Check them out. They're out there taking pictures of the night sky. Things like the Aurora Borealis. Here's his Instagram feed, stargazing and taking pictures of the night sky. So there is an affidavit in there from a bona fide astronomer. So this will absolutely go towards the alibi for Kohberger. Interesting. Okay, then we've got Officer Nunez, transcript and summary. Remember, Nunez is supposedly the first officer that arrived on the scene. Mowry transcript, Detective Gooch transcript and summary. So Gooch was another one, I believe, that I'm not too familiar with Gooch. Y'all might have to fill me in on Gooch. Emails with vehicle identification expert. You know, that's relating to the identification of it being 11 to 13. And now we know the identification of 11 to 13 was through the Ridge Road video. And then we see idiots like Gray Hughes make videos saying that the defense claims Kohberger was on Ridge Road, when clearly they said that expert identified that vehicle as an 11 to 13. And we know that's the one they found in Eugene, Oregon. Affidavit in search warrant for UPS. Interesting. The BOLO, that's the BOLO that law enforcement sent out to the public sent out to the law enforcement for a 2011 to 2013 Hyundai Elantra. Supplemental reports number 52 by Brett Payne, sealed transcript from grand jury hearings. We got two of those. 5/15/23. Of course, we don't know what went on there. Look at this. Supplemental report number 152 by Officer Gunderson. R.E. Dog. So, how did that dog get in that room with that open door? Well, according to this, and this is a memorandum in support for Frank, so it's either information that they lied or didn't add, omitted. We've got Gundy here is the one that was responsible for the report on Murphy. Now, for those of you that haven't been with me too long, you'll know that Officer Gundy is none other than the husband of Mr. T.F., Mr. Farley, his first cousin, is Gundy's husband. And he has a history of lying and removing video from evidence in previous cases. So not only is he TF's cousin, he's the one that supposedly, I guess, wrote the report on Murphy being in that room by himself with the door open. Goodness, does that mean he's the one that put Murphy in that room after all this, right before Officer Nunez's body cam video of the dog upon arrival? Did Gundy go up there, put Murphy in, then Nunez walk up with his body cam on? I don't know. Return on warrant, AT&T records, Celebrite report. Department of Justice interim policy. Letter from Latah County prosecuting attorney dated 6/24/24 to Othram. So this was just a little over 6 months ago when, again, this is a memorandum in support for Frank. So it has something to do with lies and omissions. Transcript from motion to compel hearing on 5/30/24. Again, they're mentioning that 5:30 hearing. I'm going to have to check that out again. Shoe print outside of Mortenson's room. Transcript of audio-video file for Mortenson's interview on December 30th, 2022. So that means December 30th, 2022, that's the day after they arrested Kohberger. You can bet that is Mortenson looking at a lineup for Kohberger and 5 other individuals and saying, I don't recognize him. Order on defendant's 4th and 5th motions to compel discovery, unredacted. I need to go check those out. We got 3 lab reports, sealed letters between Latah County prosecuting attorney's office and FBI, more collusion there. Sealed letter 11/28/23 from FBI to Latah County prosecuting attorney. More collusion there going on just a year ago. The Skivubsu, I don't even know how you say that, CV from Cy Ray. That's his curricula vitae. And then Cy Ray cases that he's worked on in the past. Lab report, FBI fibers, no hair, no connection. Lab report, FBI fiber, hair, no connection. Biology analyst notes, photos, negative for blood. This is, you can bet, those hairs and fibers they found in Kohberger's car and apartment. No connection, no connection. Biology analyst, that red spot they found on his pillow, tested negative for blood. So, like Drunk Turkey and all them that want to say that lack of evidence doesn't mean there was nothing. No connection, no connection. They're still to this day, even after hearing it for themselves in the hearing, they still can't get their mind around that there's no evidence connecting Kohberger to the victims in his car or his apartment. I watched him just to see if he would go, wow, this is crazy, there's no evidence. And in his mind, he started to do it, and he'd come back and went, well, but that doesn't really mean no evidence. No, guy, no evidence, Gilter. Get your mind out. DNA 123/23. Now, I thought they had their DNA already matched well before this date. So why is their DNA exhibits for January 23rd of 2023? That should have already been done. Idaho State Forensics, interview with Mortenson on 11/17, interview with Mortenson on 12/1. FBI Special Agent Hilly report regarding video surveillance. I thought it was Special Agent Imel that did the vehicle identification. Screenshots from Mitch Nunez body camera on 11/13. Wonder what that showed that they didn't... Who knows? Idaho State Police Forensic Biology Report 33, dated 5/23/23. Again, that's going to have something, I would imagine, to do with the DNA. Or it could have been biology notes on the things that they pulled from the apartment in the car. All right, now we've got motion to suppress the genetic information. Email between Gamet and Mooney at the FBI. Arizona versus Mitchell opinion from the Court of Appeals. Another sealed letter between Latah County Prosecuting Attorney's Office and the FBI. Got that collusion going there. Department of Justice interim policy. Colorado versus Phillips. Order denying motion to suppress familial DNA search, fruit thereof. So that's a case that the state cited in an objection. Motion to suppress the first AT&T warrant. Return of warrant receipt and inventory, affidavit for search warrant. This is obviously regarding them not attaching their affidavit to the search warrant when they sent it off. Pin, trap, and trace, search warrant, affidavit, receipt and inventory, trap and trace warrant. So special agent balance, exhibit C from AT&T form with warrant. Affidavit search warrant application for an order for a PIN register, trap and trace non-disclosure, Pennsylvania search warrant for Lambsden. All right, the actual search warrant, arrest warrant affidavit, state police report, general offense report, state police report, general offense report, special emergency response team event log, application, letter to Detective Payne. Here's that letter to Detective Payne from Pennsylvania Sergeant Michael Lang that was sent to Detective Payne like a couple of days before the recent hearing, and Ann Taylor made sure to point that out. Pennsylvania State Police report, general office report regarding custody of Kohberger. All right, so search warrant for Mr. Kohberger's person, affidavit, search warrant dated, Kohberger's person, search warrant for defendant's apartment, application for search warrant, motion and order to unseal, return, motion to transfer custody of items, redacted search warrant for residence in Washington, amended statement by Don Daniels, Washington State Police regarding the search for the residents. I bet that statement was amended. Cell phone USB, they got affidavit for search warrant. And then motion to suppress a memo in support of the Apple account. Federal grand jury subpoena and search warrant dated August 1st, 2023. What's interesting is they've got a preservation letter for 12/21/22 from Apple, and this would have been those federal grand jury subpoenas. And this is the only thing that's really interesting to me in all of this, because everything else came after the arrest of Kohberger, and this one would have been before they even got the warrant for the AT&T. So I'm very interested to know what that one's about. Motion to suppress the Amazon, and they're focused in on these warrants from April of 2023 and later. There's applied for March 2023. So obviously nothing to do with those initial Amazon warrants that they got prior to them getting the name of Bryan Kohberger has anything to do with Bryan Kohberger. Apparently they're stirring up some crap for, these later warrants for Amazon. And, it's probably when they went through and searched his, his history of, did he even click on something, much less buy it. Motion to suppress a memorandum in support of the Google warrants. And Google warrant 3, inventory, email between Mowry and Google. And all these happened after the arrest. Okay, and that's it. Very interesting information. So that was an educational experience. It's amazing what these court docs can provide us. I will work on more information about that Frank's hearing that they had, and maybe have another video out to you this evening. But in the meantime, please like and subscribe to the channel, post your comments, your thoughts, your criticisms, and until next time, Pavarotti's out.